A deed of assignment is a very important document in land transactions, and by land, I mean both land and landed properties. In today's video, I'll be sharing everything you need to know about a deed of assignment, what it should contain, why it is important, what makes it valid, and other tips that everyone who wants to invest in real estate in Nigeria needs to know about this very particular important land document. If you're new to my channel, welcome. My name is Tosin Omotosho, and I share on this channel real estate and business tips. All right, so what exactly is a deed of assignment? A deed of assignment is a document that transfers ownership of land or landed property from the seller, who is also known as an assignor, to the buyer, also known as an assignee. Now, if you've watched any of my previous videos, you remember I said that real estate is governed by laws. So there are laws that guide how real estate is managed, is purchased, is administered in Nigeria. And what the law says is that when you buy real estate, for there to be the transfer of those ownership, for there to be the transfer of the rights of you owning a property, it has to be in a deed. And that deed is usually known as a deed of assignment. So someone, the seller, who is the assignor, is transferring the title, the ownership of the property to the buyer, and it is done via assignment. Now, it is important to note that you should not joke with this document at all right, because documentation is what proves you as the new owner of a property. So when you are buying real estate, buying any form of real estate, whether land or landed property, built property, the deed of assignment, you must ensure that it is properly drafted and it contains the details. Now, the devil is in the details. I have been a lawyer for the past 14 years, and one thing that I would tell you for free is that when it comes to drafting contracts, when it comes to documents, you cannot afford to make mistakes, because whatever is written down is taken strictly as it is written down. So you can't say, oh, we actually wrote it, but we meant this. So everything has to be carefully and properly drafted. Now, a deed of assignment is quite a bulky document, but in today's video I'll be sharing only 6 details that are very important and that you need to pay attention to. The first is that the deed of assignment must contain the names and the full addresses of the parties, and by the parties I mean the party selling and the party buying. So you have to state, I have to let you know at this junction that property can be sold by a person, it can be sold by a group of people, it can be sold by a company, it can be sold by a non-governmental organizations, and depending on the type of entity that is selling the property, that determines how the names will be drafted. So if you have just if it's a human being who is just selling, for instance, I'm selling a property, I will just have my name as I know as Tosin Omotosho, all right? But if it was a company that is selling, then it will be the registered name of the company that has to be on that deed, whether as the seller or the buyer, the assignor or the assignee. That has to be the registered name of the company that will be on that deed. Now, if it is an NGO that is selling or buying the property, the way it will be drafted to will be different. So if it's an NGO and is registered as an incorporated trustees, for instance, so let's say it's an NGO and the NGO's name is Children's Initiative. Now the way it will be drafted would be, their names will be the incorporated trustees of Children's Initiative. All right, so it's important that the name has to be properly spelled, and it has to have the proper legal designation, or else the document is going to be invalid. Okay, so the name and the address, very important. Now the second is that there has to be a detailed description of the property. The property that is being transferred from one party to another has to be properly defined, described. Nowadays, now that we have survey plans, we usually get a survey plan done so that it will be attached to the deed of assignment, and then would also refer to that survey plan in the deed of assignment. So you would find us say that the property delineated as so and so, the survey plan number, on survey plan drawn by registered surveyor, you have the name of the surveyor, the date of the survey. All right, so it has to have all those details, because of course, we're talking about property here. The document is transferring title in the property, so it has to sufficiently identify property. Now the third thing, and this is very important, is there has to be a recital. We call it a recital of how the seller becomes the owner. And the recital is pretty much a story of how the seller came about owning that land. All right. And now there's something called root of title in real estate, and it means tracing the ownership of the parties who are selling. So if I want to sell a property now and I bought it from another person, in the documents, in the deed of assignment, it's going to be included that I got the property by virtue of a deed of assignment executed between me, my name, and then a party dated so and so. Do you understand? So it's very important that this has to be stated, because of course, you cannot give what you don't have. If the title of the person who is selling to you is faulty, then the person won't be able to give you good title. Title means ownership. Okay, so this is why this detail, you can't do without it. It's very important and has to be detailed. Remember, the devil is in the detail. The fourth, of course, is the price of the property. Very important. Where it's a deed of assignment where a property is sold, money has exchanged hands. All right. So the price of the property will be included, and we would also write it there that the assignor confirms receipts or payment of the price of the property. And then the parties have to sign. So both parties have to sign, and then they have to have their witnesses sign. So let me quickly state that witnessing a document does not mean that you have to know what is inside the document. Because I remember someone had asked me a question saying their father had died, and then they discovered that the father had sold the property, but he didn't tell anybody, but that his driver was a witness. And I said the driver is very possible the driver didn't even know what the document is, because when we say someone witnesses a document, what we simply mean is the witness is confirming that yes, so and so name written here is the person who signed here. That's all. It doesn't mean the person is going to flip over to the front page and start reading all the details in the document. It's simply to confirm that yes, this person whose name is written here is the person who signed. So it's very important that their signature has to be there. Now, the sixth thing that you have to know is that it has to contain an indemnity clause, and it's a form of protection for the buyer. All right, so the seller is saying yes, if there's any issue with the title, we will indemnify you, we would compensate you. That's what an indemnity clause is. We never miss this in a deed of assignment. So those are a few details that a deed of assignment must contain. Now, a deed of assignment has to be drafted by a lawyer, and it has to be signed by a lawyer for it to be valid. And the lawyer, of course, would have to affix his seal. For it to be valid, that is to make it legal, it has to be signed by a lawyer and drafted by a lawyer and signed by a lawyer, and also the lawyer puts his or her seal. Now, it's important to know that the buyer's lawyer drafts the deed of assignment, and that is simply because it is the buyer who would be at a loss if anything goes wrong with the transaction. All right, so the buyer's lawyer is in the best position to protect your interests. Okay, so I know that often in recent times you have real estate companies who would draft a deed of assignment. If it is in such a case, then you have a lawyer, your lawyer still review it for you, but never just go ahead and sign a document that was prepared by the other party without your lawyer looking at it and telling you it's safe to go ahead. Now, it's important that it's not just about drafting this document. Everybody must sign, because an unsigned document is as good as a worthless piece of paper. So the parties have to sign. Everybody sign, and then make sure you get a copy. Please, this is important. I remember a case I handled. Okay, this wasn't land, but it was a contract issue where the person had said, okay, so we have this agreement that we signed. I know I signed it, but I don't have a copy. So now, it's difficult to prove anything when you don't have a copy of what you signed. So it's important that you sign, the other party signs, and you also get a copy. Now, it's not just enough to just buy the property, have your deed of assignment signed, sealed, and signed by all the parties and the lawyer. You should also perfect your title. I will be talking about that in subsequent videos. So it's important to perfect your title. If the property is one where there's no certificate of occupancy on it, then you can apply for a certificate of occupancy. But if there's been a certificate of occupancy, what you'll be applying for would be to get governor's consent to the deed of assignment. All right, so that significantly improves the financial value of your property, and then it helps protect you, because if you don't perfect your title, you don't have it registered this way, if there's a court case, it will be difficult for you to prove that you are the owner. The court would only admit in evidence when the registered document. I hope this helps. So remember to click the subscribe button and to like this video so that more people can see this and watch, and share for those who might need this video. Till I come your way again, it's bye bye for now.